See, what plea will you make in behalf of your client, Mark?
Not guilty.
Are you going to ask for a continuance?
That's yet to be determined. I was only appointed this morning. I received a call at my home last evening from Judge Skelton requesting me to be in his office at 9 o'clock this morning, at which time he advised me he would like for me to undertake the representation of this defendant, which of course I gladly did at the request of the court. He had arranged for the defendant, who was in the custody of the federal authorities, to be brought to the courthouse here this morning, and after my appointment by the court, he arranged that I might have my first conference with him, which I did for 2 or 3 hours this morning. Of course, there's little time between now and the call of the criminal docket on next Monday, and it's impossible for me to judge at this stage of the game what motions will be desirable and what motions will be made. If I'm able to properly prepare his defense in that length of time, I likely will be ready for trial. Otherwise, I may well make a motion for continuance if I haven't had adequate time.
Are you familiar with any of the testimony given to the grand jury?
No. Testimony before a grand jury is secret under the law.
Are you aware of any of the evidence that has been brought against your client that will be brought up in the trial?
Well, I am aware only of that evidence of which my client at this time is aware, and such as he informed me about this morning in the conference. As you know, an indictment in no sense of the word is any evidence of guilt. Every person is presumed under the law to be innocent until that presumption is overcome by adequate proof to demonstrate his guilt beyond all reasonable doubt. I'm not aware of any such evidence as that at this time.
Are you going to be in favor of all three being tried together or separately?
That is a matter that hasn't been determined at all and isn't possible of determination at this time. We, all three counsel, for each defendant this afternoon made a motion of the court that the sheriff be directed to make our clients available for collective consultation tomorrow afternoon in the courthouse here in Madison County. Each counsel joined in that request. The sheriff readily agreed to comply, and we anticipate that the two other defendants will be brought here at that time, and that three counsel will be permitted to interrogate and consult with them collectively. My client was left here. He wasn't taken back to the federal custody tonight, and the other two are to be brought in the morning, I understand.
In view of all of the national publicity that this case has received, what bearing do you think this will have on the case?
Well, I think that a proper administration of justice and the insurance of an accused's constitutional rights are more paramount than what any other view might be taken of the case.
Do you anticipate any trouble in selecting a jury?
I have never anticipated any difficulty in selecting a jury. I have the utmost confidence in the efficacy of our jury system, and jurors are true to their oaths, as I have found, and they will not convict any man unless the presumption of innocence has been overcome by adequate proof, and I do not believe that can be accomplished in this case.
Mr. Williford, your client, Mr. Lackey, has gotten a great deal of the publicity in this case because of his supposed confession. What part is this going to play in the trial?
Well, as I stated yesterday, Mr. Lackey, upon repeated questions by me down in the Bibb County Jail, has told me that he is not involved in this crime in any way. And of course, I went down immediately upon being appointed by the court last Friday about 5:15. I canceled my Saturday appointments and went down and had a conference with him from about 10:30 to 12:30, and then went back for another conference on Saturday morning. And
have you decided yet whether you want your client tried in a group with the three or a separate trial?
Well, Russ, I'll tell you, when you're sitting at home thinking you're going to have a nice evening with your family on a Friday afternoon, and all of a sudden you're called in a case of this type and told that you're appointed, and I might say that Judge Skelton did appoint me as counsel the day that Mr. Lackey asked that he have counsel. However, it's my contention that Mr. Lackey should have been provided counsel from the very time that the warrant was sworn out. He's an unlearned man. He has a good record, a good work record. He's worked for the same company about 7 years. As far as I'm able to ascertain, he has never been involved in any criminal act involving violence, and has a good reputation. But when you have that thrown on you all of a sudden, of course, your first thought is to talk with your client. The first thought, I guess, is why did it happen to me? But nevertheless, we do our duty as lawyers, whether we like it or not. When we're appointed by the court, this is a part of our job, to cancel all appointments and to go after protecting the constitutional rights of a defendant for whom we appointed and advising him. And as Mr. Darsey has pointed out, we have made a formal motion that tomorrow at 2 o'clock we be allowed to question them collectively with the three attorneys, Mr. Hudson and Mr. Darsey and I, and the three defendants, Myers, Sims, and Lackey, all here in the Danielsville courthouse, and we want to question them. And I believe the solicitor he first objected to it, and then he reserved his decision and stated that he would tell the court by 10 o'clock tomorrow whether or not he would agree to it or whether or not he would object to it. However, we clearly think we have the right, where they're jointly indicted, to question them jointly. And that will come up tomorrow at 2 o'clock, and we'll be over then. I would say this, I think it depends to a large extent on further conferences and on this conference tomorrow as to whether or not we will sever. Of course, the state can sever, you know, and so or whether they'll be tried.
Mr. Johnson has said he's going to call all three together, but he wouldn't oppose
the
severance.
Well, I tell you, Russ, if he's going to call them all three together, then it'll be left up to us to determine. And of course, we cannot make that determination this time because, as I say, you can realize I've hardly had time really to go over, and haven't had time to go over all the areas that I need to go over, even though I've questioned him some 6 hours. And I want to question him, of course, individually quite a bit more tomorrow, too. Because, as I say, when you have a person come in like this that's not used to being in court and things of that nature, you just have to keep questioning him to get these facts, whereas the state, they have the Federal Bureau of Investigation and the Georgia Bureau of Investigation, and they write up a very detailed report, you see, and the solicitor, all he has to do is just sit down and read that report, which he can do in an hour or two. I've been solicitor of the county over in Elbert County, and I know that those investigative officers, they line it right up, and you can learn in a few hours what the state's contentions are. Of course, we do not have access to those documents. However, we feel like that under a Supreme Court decision that it might well be that we'd be entitled to have copies of what documents.
We have somewhat of a unique problem. What is this?
We have some out-of-state witnesses, and under the Georgia law, as I understand it, we cannot subpoena them and make them come in, nor can we take their depositions. So the only way that I can find out what they know is to go and talk to them and see if they'll voluntarily come down here and testify for Mr. Lackey.
You think that they would be of great help if they do come?
I think they would be of great help because I think several of them are character witnesses, and if a man's good character is not really important when he's in trouble, when is it important?
Mr. Hudson, your client, Mr. Sims, of course, is going to be brought to trial Monday. Are you going to ask for separate trial or all of them together?
I don't know at this time whether we will or not. Can't decide. We'll have to see how the evidence develops and then make a decision at that time.
Do you anticipate any trouble in selecting a jury?
No, sir, I don't think we could get a fair jury anywhere in the country and right here in Madison County.
In view of all of the publicity that the case has received and so forth, do you anticipate any problems at all coming up in the trial?
Well, certainly we'll have many problems in regard to motions and evidentiary problems. We can look forward to quite a good many evidentiary problems because we think most of the evidence that they'll intend to put in trying to weave this net around these people will be inadmissible evidence. And of course we'll object to them at the time whenever it's necessary.
What part do you think civil rights is going to play in this trial?
Well, I don't think civil rights has anything to do with it right now. This is a murder trial. The state of Georgia has no civil rights law that I know of. Maybe they do. But as far as the federal civil rights law is concerned, it plays no part in it at all that I can see. The only part it has played in it is that the president, under the guise of the Civil Rights Act of 1964, has sent the FBI down to gather evidence in a state case. And of course, we've had a lot more, well, I wouldn't say any more serious killings than this because one killing is as serious as another, but I didn't see the FBI descending on Gwinnett County when the 3 police officers were killed. They ought to send them down there too.
Is there any way you can or do you plan to raise any objection over any evidence gathered by the FBI?
Well, yes, sir, we plan to object to quite a good bit of it. We won't make known our grounds at this time because we don't want to tell them exactly what we're going to do, but we intend to object to practically all of it.
Solicitor Johnson has said he's going to oppose any continuance in the trial. Are you optimistic that there will be a continuance?
No, I can't comment on that because, as I understand, you're not supposed to comment on what the judge should do.
The trial, by evidence, the facts and circumstances surrounding the taking of that statement. In other words, just how long he was grilled and just what promises were made for leniency and offers of money and other things, and that will be brought out in the trial. And of course, any one of those things would be sufficient to make the confession, if there were a confession, which we deny that there ever was a confession. He made a statement. In fact, he made more than one statement, but none of those statements, it's our contention that they are not admissible in the first instance, and he repudiates anything in those statements which would implicate him in any way, and he denies having any knowledge of Myers or Sims being involved in any criminal act on that particular day.